Uganda law will enforce restraint of trade clauses if they are reasonable, if they are for a reasonable period of time, if they do not unnecessarily curtail a person from practicing their profession. Because overall we have a right in our constitution to practice our profession. So each case would be looked at on its own merits.
And the reasonableness of the provision will depend, among other things, the period of the restraint, the geographical coverage of the restraint, the rights of the employer, which that provision seeks to protect.
Restraints of trade are recognized in South Africa. They're also enforceable in South Africa. The restraints of trade are largely dictated by public policy.
In Kenya, contracts in restraint of trade are valid. So the mere fact that you have a provision in a contract that restrains a trade or restrains a profession from being carried out does not mean that the contract is invalid. However, when it comes to the enforcement of that contract or provision, it is required that the provision must be reasonable considering all the circumstances of the case.
Important considerations in a restraint of trade in South Africa are the area of the restraint of trade and the duration of the restraint of trade. Those are required to be reasonable. It's not a legal requirement in South Africa for an employee to be paid in exchange for being restrained, but in terms of public policy, if the employee has been paid for a restraint of trade, the restraint of trade is more likely to be enforceable.